Defendants attacked Twitch's artifact game directory. Twitch has attempted to identify the individuals responsible for the attack. Twitch would be prejudiced if the case were dismissed. Those defendants closed their email accounts after receiving notice of the case.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
The Twitch artifact lawsuit has a giant, well, I like to call it a giant update. The Twitch Corporation plaintiff has asked for an extension until December to continue to find and serve the defendants, the John Doe defendants in the case. And in here, they will explain their efforts to find some of the defendants, and you'll be able to see if they're finding some of the defendants and what kind of luck they're having with that. So this could be good, this could be bad. Let's take a look. Now before the court is Plaintiff Twitch Interactive's ex parte application to extend the deadline for service. Ex parte means without the opposing party, and at this stage that's normal because they are suing John Does and they don't know who the John Does are yet. Having considered Twitch's motion and the pleadings and the papers, the court grants the motion. They now have till December 11th. And here is their application then, which we've redacted out, or I redacted out because there are some email addresses in here, and I figured while I'm in the middle of redacting it, I might as well redact out the attorney's phone numbers and emails because don't want any more trolling. This is the plaintiff's ex parte application, and it says, please take notice that Twitch Interactive applies to the court for a 90-day extension under Federal Rule of Civil Procedure 4M. This motion complies with Local Rule 710, as Twitch is in the process of attempting to determine the defendants' identities, and Twitch may not receive responses to its subpoenas until mid-October. This is normal. Even though Twitch got the order granting the subpoenas weeks to months ago, Twitch has to then prepare the subpoenas if they weren't already, send them to the ISPs, the internet service providers, and web host, I believe, was one of them. And then those providers have to notify their clients or subscribers under the Cable TV Privacy Act of 1984, which basically says you have a due process right when someone subpoenas your identity. So they have to be notified, given an opportunity to file something with the court, like a motion to quash if they believe they have grounds to do so, or at least not respond, and then the ISPs and web host, etc., when they let a 45-day period or 30-day period, it's reasonable time, and every court sort of interprets that differently. When they let that time expire, then, and only then, will these subpoenas be responded to. So some of the subpoenas just simply haven't been responded to because it's not yet mid-October when that period will expire, and either we'll have a filing from somebody filing a motion to quash, or we won't, and then the ISPs and web host will respond to the plaintiff with the John Doe's identities. And it doesn't necessarily mean that the ISPs have all the identities. It just means they'll respond with what they have. Anything that falls under the subpoena, they'll have to respond with that information. Good cause exists for this request because Twitch has diligently investigated, attempted to identify and locate the defendants, including serving subpoenas authorized by this court on third parties with potentially identifying information. This motion is based on the Memorandum and Points of Authorities and the declaration of Holly M. Simpkins. We'll look at that in a moment. And then here's their footnote. Twitch will send a copy of this motion to the email addresses associated with several of the defendants. And I've gotten rid of the emails except for the first letter or two. So the SK email address, the JFE email address, the GA email address are all people they're looking for and have been unable to contact. Some of them were returned undeliverable, and some were not returned undeliverable. So it seems like the email addresses may have been working and then turned off after the notices were sent. So they remind the court, defendants attacked Twitch's artifact game directory by broadcasting content that violated Twitch's terms of service and other policies, Twitch sued the defendants for breach of contract, trademark infringement, trespass to chattels, and fraud. Since that time, June 14th, Twitch has attempted to identify the individuals responsible for the attack. To assist in those efforts, Twitch received permission from this court to serve 11 third-party subpoenas on internet service providers, email companies, and social media companies. Because responses to those subpoenas may not be returned until mid-October, approximately 1 month after the current September 12th deadline, Twitch seeks a 90-day extension. Then they go into what's going on here. We know all about Twitch. Beginning May 25th, 2019, defendants co-opted the game directory for Artifact to broadcast prohibited content, including hardcore adult entertainment, racist, misogynistic videos, videos depicting violence. Despite Twitch's swift action against the accounts used to stream this content, new streamers appeared quickly and reposted the offending videos. Defendants also made unauthorized use of Twitch's intellectual property, including its glitch and Twitch trademarks. So then Twitch investigated. You will read the declaration of their attorney, Holly Simpkins, and they filed the motion. The court granted the motion. Twitch served the subpoenas. The recipients have 30 days to respond, plus there's probably some mailing times in there. So they argue under Federal Rule of Civil Procedure 4M that the court must extend time for service for an appropriate period if good cause is shown. This is a very simple rule on extending time. If there's good cause, you can get more time. Just show the court what the good cause is. Maybe don't call the court a BACMF in the process, and I bet you'll get even farther with it too. To demonstrate that good cause exists, the court may require plaintiffs to show, in this case with a early subpoena, the party to be served received actual notice of the lawsuit, the defendant would suffer no prejudice, plaintiff would be severely prejudiced if his complaint were dismissed. The Ninth Circuit observes that good cause may include the following circumstances: where the defendant has evaded service, where service was attempted but not completed, where the plaintiff was confused by the requirements for service, where the plaintiff was prevented from effective service by factors beyond its control. Good cause exists here. Twitch attempted to identify the individual social media accounts, track down them through websites, and identify IP addresses. They sued the defendants and sent copies to 3 email addresses connected with them. They received no response. They applied for an application for expedited discovery to subpoena 11 third parties. They promptly served the subpoenas in mid-August. Twitch cannot serve the defendants until it has their identifying information. The remaining good cause factors also support Twitch's extension request. First, Twitch provided defendants notice of the lawsuit at the email addresses. Defendants also received notice from the subpoena recipients. Second, defendants would not suffer prejudice from an extension because the case is in its early stages. Third, Twitch would be prejudiced if the case were dismissed, and the resources Twitch invested in investigating the attack, bringing this action, and attempting to serve defendants would be wasted, and a denial of the extension would reward defendants for evading service. Even if a plaintiff does not show good cause, the court may exercise its discretion, etc., etc. Here, there is little, if any, prejudice to defendants. The case is at its early stages, the delay is minimal, and Twitch will promptly serve them when it can. She sent a cease and desist letter, a copy of the complaint, and a waiver of service form to the 3 email addresses, and they were not returned as undeliverable. The letter asked the individuals receiving these messages to identify themselves and waive service. They did not receive a response. Shortly after the court granted the subpoenas, they tried again, August 7th, and the 3 email addresses were returned undeliverable. So it seems like those defendants closed their email accounts after receiving notice of the case. Well, that's not going to work out great for them. I think the providers already know who they are, and we'll see if Twitch can get at them. And we'll be bringing you more updates to this case when they drop. So that's how an expedited subpoena works. Expedited means that we're doing a subpoena before we get to the proper stage of a lawsuit. Normally a subpoena is for discovery of evidence and testimony and you wouldn't do that until you got past the complaint filing and the answer to the complaint. Service of process would be in between there. You would go through in federal court a Rule 16 conference, and you'd exchange Rule 26 disclosures of required information. None of that's happened here because the defendants' identities are unknown. So first we're going to uncover the defendants' identities, then they'll proceed with a proper procedure of sending them the complaint and serving them, and they'll have to answer or file a motion to dismiss. And then we'll get into discovery after those Rule 16 conference and Rule 26 disclosures. So that's when the rest of the discovery will happen. This is just the preliminary stage. Once they get done with this, we still have 2 years of lawsuits to go in this litigation process here. So this is going to be a fun one to keep track of. So what do you think so far? Should these people reach out to Twitch and try and resolve the matter? I'm not gonna give anybody advice here, so I'm not gonna say yes or no. What do you think? If someone reached out, well, that might eliminate any possibility that maybe they can't be found. So how do you know what to do? I have this same conversation with my actual clients on an almost daily basis. What is the right thing to do? Do you wait or do you respond? And sometimes we wait and sometimes we respond. And no, I'm not going to tell you when, because that involves individual circumstances that are, one, confidential for my clients, and two, I don't have enough individual information about anybody else's case here. Those 3 email addresses, I could not tell you whether it's a good idea legally to respond or not just because I can't give legal advice, but because I can't give legal advice because I don't have enough information. And so those people should be in touch with their attorneys. And if the decision with their attorney is not to respond, yeah, maybe they're making the right decision. And if they haven't talked to their attorneys, I mean, that's their prerogative, but I'd recommend it. And for the record, I'm not offering, but if somebody does contact me, I'm certainly not going to turn them away from a conversation. I might choose not to represent them, but I'm not offering, is what I'm trying to say. Let me know what you think. So thank you for joining us. I am Leonard French, your favorite copyright attorney. Thank you very much for your support. This is a community-supported legal education channel, and we are about to take this thing to the next level. Brandon is going full-time. We are going to register as a corporation and then eventually, shortly here, a nonprofit. We're figuring out which country, because I'm in Luxembourg now, and I still want to live in the United States, and I still want to come back to see Kaylee in Luxembourg. So we're figuring it all out. And very shortly here, we will have some answers. So we really, really appreciate your support, and we might even do a GoFundMe at some point to see if we can build a little corporate safety fund for paying Brandon and paying writers and paying editors and taking this thing to the next level. We really appreciate your support. Thank you to Joshua Davis from TandaPay, who has supported us, sponsored our channel in the month of September. We are working on his TandaPay video, and hopefully that will be out very early this week. We will explain everything that's going on there and make sort of a legal analysis of whether tandas, which are these small loans to one another, but this is more than that. It's also kind of a social insurance program. So it's a really cool and interesting technology, and we're going to explain how this is going to work when he releases his technology. Whether it's going to be an app or how you're going to use it and all that, we'll let him explain at that point. But we're going to go over the legal side of it and see how this would work. So thank you very much to Joshua Davis from TandaPay. And thank you to our $50 plus supporters for the month of September: John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, and blackleaf. And thank you to the $5 plus supporters who will be scrolling on the screen in front of me. Have some video from our trip that Brandon will put up on the screen of the edited videos. And until then, I love you all. I'm Leonard French, your favorite copyright attorney, and I'll see you in the videos.